Welcome to the series of important questions in drafting. I am C.S. Pooja. In this video, we will be covering the questions asked in 2014 to 2018 exam from the 6th chapter of drafting, drafting and conveyancing relating to various deeds and agreements, part 4. For students in the new syllabus, this will be chapter 10, Art of Writing Opinions. The portion on writs and special leave petition is exactly similar as per the old syllabus, but the part on legal opinion is different. Since June 2019 will be the first exam under the new syllabus and there are no questions to refer, the new syllabus students can look at self-test questions at the end of chapter 10 to get an idea as to what kind of questions can come from legal opinion. But for the rest of the topics of writs and special leave petition, this video will be useful. Starting with the questions asked from writs, the question was to explain the various types of writs under the Constitution of India. This was asked twice, once in June 2015 for 8 marks and the second time in June 2017 for 4 marks. There are 5 types of writs under Constitution which you need to explain. The basic meaning of a writ is an order. An order by whom? An order by the Supreme Court and the High Court, and the Constitution gave the powers to these courts to give these orders under Article 32 to the Supreme Court and Article 226 to the High Court. Mentioning these articles is important for the answer. Writs or orders are given by the Supreme Court and High Court only when there is no remedy under any other law in India or the remedy under any other law is not sufficient. So the first type of writ is writ of habeas corpus. This writ is available to a person who is confined without any legal justification. The second kind of writ is writ of mandamus. This writ is issued by the Supreme Court or High Court to any public authority who is abusing its power and ordering it to do its public duty properly. The third writ is the writ of prohibition. When any court or judicial authority is acting in excess of its jurisdiction, that is, in excess of its powers vested in it, the Supreme Court or High Court issues this writ asking it to act within its powers. The important thing to remember here is this writ is issued only when any case is pending in court. The fourth writ is the writ of certiorari. In this writ, when any inferior court or authority has already passed a decision or judgment which it did not have the power to pass, the High Court or Supreme Court passes this writ to quash or reject that decision. The fifth writ is the writ of quo warranto, which is issued by the Supreme Court or High Court to inquire if any person who is occupying any public office has the legal authority to occupy it. Like this, you can explain the types of writs in brief for the above question. Next, many differentiation-based questions have been asked on the types of writs, like distinguish between a writ of mandamus and writ of certiorari, distinguish between habeas corpus and quo warranto, distinguish between prohibition and certiorari. All these questions were asked for 4 marks. Also, there is a high chance of asking to draft a specimen of writ petition, so please know that also. The next important topic in this chapter is special leave petition. The question asked were, what are the provisions in the Constitution regarding filing of a special leave petition? This was for 8 marks in June 2017. And write a note on special leave petition. This was asked for 4 marks in December 2018. So 3 articles of the Constitution deal with special leave petition, which are Article 132, 134A and 136. So Article 132 states that appeal shall be made to the Supreme Court from any judgment, decree or final order of the High Court in any civil, criminal or other proceedings, and for this the person who wants to make the appeal should file a petition to the High Court to grant special leave appeal, and if the High Court feels that the case involves a substantial question of law, the High Court will grant or certify special leave to appeal under Article 134A of the Constitution. Now, when the High Court refuses to issue the required certificate to enable the aggrieved party to appeal to the Supreme Court. The aggrieved party may directly petition the Supreme Court for grant of special leave petition to appeal against any judgment of the High Court. Article 136 states that the Supreme Court is authorized to grant special leave to appeal in its discretion, that is on its own, against any judgment, decree, sentence or order passed or made by any court or tribunal in the territory of India except military tribunal. Therefore, the Supreme Court has wide powers through Article 136, and this power cannot be curtailed under any other law. Therefore, we can say that special leave petition under Article 134A and 136 of the Constitution are similar in form and same in essence. Next question was, under what circumstances the Supreme Court of India can entertain appeals in cases where law does not provide the right to appeal. This was for 4 marks in June 2016. So under Article 136, in cases where any arguable question, mostly question of law, is involved, the Supreme Court may at its discretion or on its own take up appeals, even in cases where an appeal is not otherwise provided for. But when a question of fact is involved in a case, the Supreme Court will entertain the appeal only when the High Court or any lower court finds any things in the case which shocks the conscience of the court. Next question is, draft a special leave petition before the Supreme Court of India and assume the data. This was asked for 12 marks in December 2017. So this whole draft along with the affidavit has to be drafted as shown here. Opinion writing is a very important topic, so everything under this topic is important. The question asked from here was, write a note on need for a legal opinion. This was for 4 marks in December 2016. For the answer, first explain what is opinion writing, which is nothing but a professional's advice and instructions to his clients in writing, but it must not just contain advice but also the basic reason behind the professional's advice. Then write the need of legal opinion as given here. Next question is, comment on the following. Formulation of a legal opinion needs certain precautionary measure. This was for 5 marks in December 2018. The answer for this will be, a request for legal opinion will come in a written form, and such request will include one or more question for advice. First thing to see is if the client has a strong case. In case no, they should be advised about this in the course of the legal opinion. Next is to see if something can be done to improve the client's prospectus of success. This should be mentioned clearly in the legal opinion. Since legal opinion is advice, you should not sit on the fence. Means lay down both the pros and cons, but a side has to be taken by the professional. Last, give the percentage of success of the case. So this last part is this part is not part of the last answer, but the portion on drafting of legal opinion should always be split into 3 processes, that is mental attitude, thinking process and writing process. Know all these points very well because lot of questions can be asked from these 3 points. From here the question was, examine the following statements. A legal opinion should be structured. This was asked for 4 marks in December 2015. So just knowing your legal opinion won't do. You should express yourself, that is, know how to transfer your thinking process on paper. So writing process is not a mere formality. The legal opinion should be written in the following structure. So the first para of the legal opinion should be an introduction to the legal opinion. What are the facts of the case and what you have been asked to advise. At this point, many legal opinions will set out the main conclusions and advise an overall opinion. This is a good practice to use, which will help the client to understand better and will know where the opinion is leading. So percentage of success of the case may also be stated here. The subsequent paras set out reasons for reaching legal opinion. This is when the legal structure comes in. Each issue should be taken and the reason for your opinion should be explained. And the concluding para of the legal opinion should be the next step. That is, what can be done to strengthen the case. So, this is how every legal opinion should be structured. Last question from legal opinion was, critically comment, writing process is an essential part of legal opinion even if composed on a laptop. This was asked for 5 marks in December 2014. So the answer will be, a legal opinion is professional written response in the form of instructions to clients, and the reason behind these instructions need to be explained as well. So composing a legal opinion involves 3 processes, as we know, that is mental attitude, thinking process, and actual writing of legal opinion, writing being the most important. Today, most of the legal opinions are drafted in electronic format, that is, they are composed using laptops, and just the fact that legal opinions are drafted in laptops without using pen and paper does not dilute the importance of writing. So with this, we come to the end of this chapter. For the videos of the previous chapters, please check the description box below. Thank you for watching and please subscribe to Excel Academy.